What's going on, everybody? Welcome back to the Butterfly Monkey Effect channel. Today, of course, is a continuation on the Manual on Commercial Law by Lavine, the National Edition. This will be Chapter 2. No doubt it will be at least 3 videos. So, Chapter 2 on Contracts. Section 104. Scope of this chapter. In this chapter, we shall consider the formation, the requisites of a contract, the form in which contracts may be executed, and the operation and effect of contracts, and the manner in which contracts may be discharged. We shall also consider briefly how contract disputes may be arbitrated. So that's the scope. A lot of it's basic. Hopefully, a lot of you are already familiar with a contract law book. The older, the better. I got a really good one from 1934, right, for contracts for Illinois. It's well worth the read. That's for sure. Part A: Formation and requisites. Definition and nature. A contract is defined as an agreement upon sufficient consideration to do or refrain from doing some lawful thing. The agreement must create an obligation. This obligation takes the form of a binding promise, expressed in words or implied from conduct. To be binding, the promise must have been given in exchange for something of value, such as an act, paying money, delivering merchandise, rendering service, or a promise to do the act, or else the giving up of some right. So a negative, right? Giving up of some right, privilege, or benefit. Such a thing of value is termed consideration. So it's always either it could be consideration, it could be a detriment or a positive. It's always about a give and take. Requisites of contract. There are certain requisites which every contract must have. If it lacks any one of these, it is void. These requisites are mutual assent, parties with capacity to contract, consideration, and valid subject matter. To these, the additional elements of time and form are sometimes added. And they give an example there, but you got to remember when the chapter here is contracts. But you got to remember, damn near everything is a contract. Negotiable instruments, promissory notes, bills of exchange, trust documents, right? These are all contracts. So it's like out of those specific examples, right, or the specific required format for each one of those, right? For each one of I just named, they have a specific way of writing each specific one. So that's like what they're saying here. Don't lack one of these things that each one is required. An example: in consideration of the sum $250 in hand paid by Richard Green to Harry Brown, receipt whereof is hereby acknowledged. This right here is the acceptance. This right here would be considered funding the trust if this was written in such a way to say that this money, instead of in consideration for that transferred into trust, and then he's saying that he acknowledged it. That right there is funding the trust, would be funding the trust. It is hereby mutually agreed that Harry Brown is to ship and deliver to Richard Green to his address 1,000 pounds of real coffee, superfine blend, not later than 12 o'clock noon on June 1st, 1948. So the promise to deliver to do an act in the future, but he paid this. The form of the contract given in the above example may be oral or written. Mutual assent. Mutual assent consists of two things: an offer and an acceptance. The offer itself must conform to certain requisites. The acceptance must meet the offer exactly. Otherwise, the assent is not mutual. No contract results. Requisites of offer. An offer to serve as the basis for a contract, A, must be seriously intended as such, B, must be communicated to the person who is to accept it, and C, must be definite and certain. Offer must be intended as which? Invitations to trade. An offer must be intended on the basis of a valid obligation. This excludes offers involving social functions such as theater or dinner parties and so on. It also excludes invitations to trade. Price lists, circular letters, and most advertisements are construed as invitations to trade. So are most offers to sell an indefinite quantity of merchandise. Examples: a storekeeper contracts with a newspaper to publish an advertisement of its merchandise, including items priced at $15 each. The price is erroneously published as $5 instead of $15. The storekeeper refusing to pay for the advertisement asserts a claim against the newspaper for losses sustained through having to sell his articles at $5 instead of $15. The claim is unfounded. The storekeeper was not obliged to accept such losses. His advertisement did not constitute an offer, but only an invitation to trade. That's tripped out. A stationery company writes, example number 2, a stationery company writes to a certified public accountant: we have quite a few pads of slightly defective but completely usable analysis paper, which we now offer you at 45 cents per pad. So they're giving that as an example. They don't elaborate on that though. They give you section 1384. Section 110, offer must be communicated. One cannot accept an offer of which he has no knowledge. A particular offer is one made to a particular person or persons. An offer made to one person cannot be accepted by another. A general offer is one addressed to the public, as by a newspaper, advertisement, poster, bulletin, and so on. Offers of reward are frequently thus made. A general offer of reward for those doing of an act is not accepted where one does the act without knowledge of the offer. Carter publishes an offer of reward for information leading to the discovery of the murderer of his brother. Martin, without knowledge of the reward, gives the desired information. Later, upon learning of the reward, he sues to recover. His suit must fail. Gotta know ahead of time. Signing without reading, which a lot of us have done over the years. Probably most still do. If an offer is brought to the attention of an offeree in such a way that a person of ordinary intelligence would be presumed to have knowledge of it, communication of such an offer will be presumed. Hence, if one accepts a written offer as by signing a paper, later claims he had no fair opportunity to read it, he is bound by his acceptance and cannot shelter himself behind the defense of ignorance, even if in fact he did not read the offer he accepted. Inability to read what one signs because of defective eyesight is no defense if one signs notwithstanding. Signature procured by fraud. If a signature is procured by fraud, the offeree is not bound. Hence, a contract procured by trickery is unenforceable. Example, in Wilcox v. American Telephone and Telegraph Company, a farmer was induced by the company's agent to sign a paper represented to be a receipt. In reality, the paper was a document giving the company a right to erect poles on the farmer's land. The court refused to recognize the document because of the trickery, though the farmer had an opportunity to read it. Had the farmer signed through ignorance, but without trickery, he would have been bound. Inconspicuous type. If an offer contains terms so inconspicuous that the average person would be unlikely to see them, such terms may be presumed not to have been communicated. Matter printed in small type on the back or at the foot of a letterhead or billhead, or in the margin of office stationery, may be deemed excluded because insufficiently communicated, unless attention is called to it in the body of the writing. So like microprint, right? So what will get your attention? The little symbol with the little circle MP on there is big enough to see, to show that the line is not an actual line or something like that. Offer must be definite and certain. Vague and indefinite offers cannot furnish the basis for acceptance. Otherwise, it would be difficult to determine whether a breach was communicated. Examples: B hires A on a salary of $40 a week plus a fair share of its profits of the business. 2. A buyer agrees to give the RS brand cement the preference in his sales for the year 1948, and in consideration thereof, the seller agrees to sell said name brand of cement to the first party during the year of 48 at the price of 95 cents per bundle, I'm going to guess. I don't know what FOB stands for. Haverstock, New York. Each of these proposals viewed as an offer is too vague and indefinite to furnish the basis for an acceptance. Form of offer. Offers may be oral or written. Oral offers are those made by word of mouth, face-to-face, by telephone, or by radio. Written offers are those made by letter, telegram, advertisement, or other written medium, as by presenting a formal contract for signature. Disposition of offer. 3 things may happen to an offer. It may be revoked, rejected, or accepted. We shall consider the effect of each upon each offer. Revocation of offer. An offer may always be revoked, withdrawn, before it is accepted, with 3 exceptions. With 3 exceptions. 1. In all states, a promise to hold an offer open for a given time, namely an option, right? So if you have an offer that's and you gave them an extension to think about it for 60 days, that's an option. Is binding, provided the promise is based on consideration. So if I gave you a coin to take this into consideration for 60 days, that's a binding offer. 2, in some states, New York, an example, at least 1948, this year of the book, right? In some states, New York, for example, a written option is binding without current consideration. And 3, in few states, reflecting the common law rule, an option under seal is binding because a seal under common law imports consideration. You know what? I want to read that. Imports consideration, section 148. Because I have a book. It's a full book, 1,000-page book. And the whole thing is about consideration. Case law after case law after case law. Oh, 145. So it's like finding little things about how consideration is construed is important. Even though this is this chapter, I wanted to go ahead and read this first. I want to read 44 also. Consideration, nature and necessity for. Consideration is something of value given for a promise. Without it, a promise is nudum pactum, a naked pact, without force of law. A promise supported by consideration is binding, that is, a contract. Example, A, by written contract, buys B's dry goods store, pays $2,000 down, and agrees to pay the balance of $2,500 on or before February 1st. On February 1st, A secures B's agreement to postpone payment until April of 48, but immediately thereafter, B, ignoring his promise, sues A for the balance. This suit will succeed. B's promise was naked, not supported by consideration. Oh, that's crazy. So it's basically he told him a lie, right? The guy wanted an extension till April. The seller of the dry goods store lied to postpone it because there was no consideration between the two. His failed. So the first contract, is what gets executed. An act versus promise as consideration. The thing of value called for by a promise may be either an act or a promise to do the act. If an act is called for as consideration for a promise, only the act, not the promise to perform it, will constitute consideration to bind the promise. Example, a promise to pay $50 if you can deliver the coal to my bin by Friday becomes obligatory, not upon a promise to deliver the coal, but by the act of delivery itself. This is known as a unilateral contract. On the other hand, if a promise or commitment to do the act is called for, the making of such promise or commitment constitutes the consideration to support the other promise. That is, each promise immediately becomes obligatory because of each other. This is known as a bilateral contract. It wasn't what I was looking for, but still worked out. Oh, what was that? Wasn't that right here? Sorry for this. Right here. That's where I was at. Exactly. So I went to I even read the wrong one. Section 148. Oh my God. I gotta do it. It's a pet peeve. I gotta do it. 148. I was reading 144 and 145. Okay. Options and mutuality. An option is a promise to hold an offer open. Like any other promise, it is ineffective without consideration. In a limited sense, options dispense with mutuality since one of the parties may be bound or not as he sees fit, while the other is absolutely bound. This is especially true where the statute, as in New York, provides that a written option is binding without consideration. In reality, however, an option where there is consideration is mutually obligatory. One party is obligated to furnish a consideration and the other to hold an offer open. In a few states, reflecting the common law rule, an option under seal is binding because the seal at common law imports consideration. So they just repeated the same thing up there. Example, on May 1st, A sends B a formal written offer under seal to sell B certain merchandise at a specified price at any time up to May 15th, so 15 days. On May 5th, A writes to B withdrawing the offer. Upon receiving the letter of the withdrawal, B formally accepts the offer, then sues for breach of contract. In states recognizing the common law rule that a seal imports consideration, and also in states where require no consideration where an option is in writing, B would succeed. In other states, B would fail since A's option was not supported by consideration. But Ben, you know what I'm saying? Like, where's the case law for this right here? What makes the seal consideration? What did that do? 43. What's 43? Sheldon versus Bright, a Kansas case. Storch versus Dunk, Minnesota case. Hartford, Connecticut Trust Company, another a Connecticut case. I don't know that this type of thing right here is what it will bother me until I figure out a little bit more information about it. Because how could a seal, be consideration? I'll find out sooner or later. No, it'll probably be in that book I got too. All right, sorry for the sidetrack here. And this example was A offers to sell B 3 dozen hats to give description of a given description at a given price on given terms. A also agrees that the offer is to remain irrevocable for 2 weeks. The offer may be revoked at any time before it is accepted. What? A also agrees that the offer is to remain irrevocable for 2 weeks. The offer may be revoked at any time before it is accepted, with the exceptions noted above. So basically, after the agreement, it's irrevocable for 2 weeks. But after he agrees to it, then it's revocable up until, especially if it's an option, 30 days. An offer may be revoked in the following ways. Expressly, if I have made you an offer and no longer wish to be bound by it, I owe you the duty of communicating my revocation to you. But whether I have communicated the revocation or not, if you learn, no matter how, that the offer is no longer open, you cannot accept it. General offers may be revoked in the same way they were made. For example, today I advertise a $50 reward in a newspaper for the return of a lost ring. And tomorrow I advertise a revocation in the same newspaper. You see the first advertisement, but not the second. Then find the ring. You cannot collect the reward. By lapse of specified time. When a time is fixed for acceptance, the offer is deemed revoked by lapse of time. However, with the exceptions noted, one may revoke an offer even before expiration of the time fixed for acceptance. By lapse of reasonable time, an offer automatically lapses if not accepted within a reasonable time. What constitutes a reasonable time depends on the circumstances, and a lot of it, is governed by statute. So, especially public communique, right? Dealing with banks, general accounts, and so forth. Dude, it's all 15 days, 30 days, commercial process and stuff. By death or insanity, an offer, unless first accepted, lapses upon death or insanity of the offeree or offerer. There can be no offer without a mind behind it. And look at the Masonic Temple versus Ebert. That was the annotation for this right here. If the offer is no longer open, you cannot accept it. Rejection offer. An offer is extinguished by rejection. It cannot thereafter be accepted unless renewed. Example, flat rejection. An offer to buy 100 barrels of flour from B at $15 a barrel at 20 days credit. On 20 days credit, B refuses. Rejection by counter offer. A offers to buy 100 barrels of flour from B at $15 a barrel on 20 days credit. B first replies, I accept your offer and will ship the goods, but on 10 days credit. And later, after A receives his letter, B writes again, I have reconsidered and will allow 20 days credit. I am shipping the goods. A need not accept the goods. B's first counter offer rejected A's offer. So just by him giving, countering it by saying 10 days, automatically countered the first one. So A is not obligated to accept. It's a trip, all the intricacies of these things, of what concepts of offer and acceptance and so forth. Because your behavior is really what's being quantified, I guess, so to speak, right? To be able to, on paper. Acceptance. Acceptance of an offer constitutes a meeting of minds and results in a contract. But the acceptance must be unqualified and must conform with the terms of the offer. Thus, if the offer specifies that acceptance must be made in some particular way, as by mail, telegraph, cable, and so on, it must be made in that way. If the offer specifies no mode of acceptance, it may be accepted in any way, provided the acceptance is actually communicated to the offerer. Offer and acceptance by mail, telegraph, cable, and so on. Offers, acceptances, revocations, and rejections by mail, telegraph, cable, and so on can be understood better if we consider the following hypothetical situations in which A and B have no way of inner communication except by messenger. A sends an offer to B by messenger, and before B accepts, A sends another messenger to revoke the offer. The second messenger arrives with his revocation before B accepts. The revocation is communicated. The offer is withdrawn. B no longer can accept. And I would have to say it's because the messenger is the witness. That's the date. So like the date of his signature of acceptance had to be before the date of the messenger arriving. If B gives the messenger an acceptance while A's second messenger is on his way with the revocation, but before he actually delivers it to B, there is a contract. Well, that's like what I just said that. And the revocation, when it arrives, is too late. If A's first messenger departs right after delivering the offer without waiting for the acceptance, and B sends his own messenger to accept the offer, the acceptance is not effective until it is actually delivered to A, which makes sense. The messenger left, right? His agent, right? He left. His witness. And if B's messenger tarries on the way or loses the message, and A, in the meantime, sends his messenger back to B with a revocation, there can be no acceptance after the revocation is delivered. B must look to his own messenger for redress, which is true. Like, what happened? Did you not make it? Oh, that's... If A's offer stipulates that A can be accepted only by delivering an acceptance to A's messenger, B cannot accept through a different messenger, which is true. You have to tell my messenger before he departs. You got 24 hours. He's going to stay at the hotel, and let him know in the morning. If A's offer stipulates that he is not to be bound by the acceptance unless and until A's messenger returns and delivers the acceptance to him, there is no contract until the acceptance is actually brought back to A by the messenger. And that's the best way right there. You make it specific on the communique on your contracts. So this way, they can't get out of shit like you would think. The foregoing hypothetical situations may now be adapted to offers by mail, wire, or cable. If I employ any of these agencies to communicate an offer, and if I do not prescribe a particular mode of acceptance, you may accept by the same or any other agency. If you accept by the same agency, my agent, the acceptance becomes effective when it is delivered to such agency. So literally right then and there, when the messenger got there and he was told yes. That is when it is mailed or delivered to the telegraph or cable company, as the case may be. If I mail you an offer and you wire an acceptance, I am not bound if your wire is lost in transmission. You must look to your agent for redress. An offer by mail may be withdrawn or rejected so long as it is not already thus been accepted. Examples. A wires an offer to B at 9 a.m. which is received by B at 11:15. So 15 minutes. B wires an acceptance at 12:45, so an hour and a half later, which reaches at A at 4:15 p.m. At 2 p.m., however, A had wired a revocation which reached B at 3 p.m. Is there a contract? No. Wires an acceptance. Yeah, there's a contract because he accepted at 12:45. As long as he did the correct acceptance procedure, like wiring. So there is. A's revocation was communicated 2 hours and 15 minutes after B's acceptance. 2. A in New York makes an offer by mail to B in Buffalo. B posts an acceptance and later wires a withdrawal of the acceptance. B's wire reaches A before the letter. Is there a contract? Yes, B's wire, though it reached A first, could not destroy the contract which arose by posting the acceptance unless A acquiescence and B's withdrawal. So they're saying because of the mode, right? One is by mail and the other one is by wire. And this is all based on some formal agreement of how we're going to communicate. But the only way that it would be accepted as no contract is if A acquiescence to B's withdrawal. Like the wire didn't matter if he sent it by wire. A in New York airmails an offer on Monday to B in San Francisco, which B receives on Tuesday morning. Immediately on receiving A's offer, B sends a night letter accepting A's offer, which reaches A on Wednesday, so literally a morning over. On Tuesday afternoon, however, A wires B withdrawing his offer. That wire reaches B Tuesday night, 10 hours before he sent the letter. No, there's no contract then. When B accepted by night letter telegraph company instead of by mail, he chose his own agent or agency to deliver his acceptance, and such acceptance was not complete until it actually reached A. Had B accepted by airmail or even by ordinary mail, acceptance would have been complete on posting. Had A specified that acceptance must be by airmail only, there could have been no acceptance at all except by airmail. 4. On October 10th, A mails an offer to B to sell 150 tons of steel filings, second grade at $66.50 a ton, subject to actual receipt of your acceptance at this offer by mail not later than the 21st. B receives the offer on October 12th. He mails an immediate acceptance, which, however, is lost in the mails. Is there a contract? There is not. The offer required actual receipt of acceptance. Acceptance after rejection. On principle, an offeree's rejection, like his acceptance, should become effective on delivery to the offerer's agency. This, however, is not the rule. Rejection by mail or telegram does not destroy the power of acceptance until received by the offerer, but limits the power so that the letter or telegram of acceptance started after the sending of the rejection is only a counteroffer unless the acceptance is received by the offerer before he receives the rejection. That just sounds all kinds of confusing. They give you a court case, though. The Reinstatement of Law of Contracts, Section 39. On principle, the offeree's rejection, like his acceptance, should become effective on delivery to the offerer's agency. But they're saying that's not the case. Rejection by mail or telegram does not destroy the power of acceptance until received by the offerer, but limits the power so that the letter or telegram of acceptance started after the sending of the rejection is only a counteroffer unless the acceptance is received by the offerer before he receives the rejection. Example, A makes B an offer by mail. B immediately mails a letter of rejection. Then within the time permitted by the offer, right, so say if it's 15 days, B accepts. This acceptance creates a contract if received before the rejection. Auctions. Auctions are governed by the following rules relating to offer and acceptance. The auctioneer merely calls for offers, and the bidder makes the offer, and acceptance is complete when the hammer falls. Silence, no acceptance. An offerer cannot compel an offeree to speak or act on penalty of construing silence as acceptance. An offerer cannot compel an offeree to speak or act on penalty of construing silence as acceptance. Example, a stationery store voluntarily delivers a package of analysis paper at the office of an accountant with a sealed letter stating that unless the paper is returned in 10 days, the accountant will be deemed to have accepted it at the price stated. The package and letter are accepted by the accountant's clerk as a matter of routine, assuming that there have been no prior transactions in which the accountant has accepted and used paper in this manner, like a history, which might create an inference of acceptance based on prior conduct. The accountant is not liable for the paper. Neither is he required to answer the letter or return the package. Of course, if the accountant reads the letter and uses the paper, he voluntarily accepts the stated terms on the letter. Oh man, that says it for itself then, right? Agreements to agree. An agreement to reach an agreement is no agreement at all. Mutual assent must be voluntary. The law cannot compel a voluntary assent. Hence, an agreement to agree has no force in law. Agreement to formalize agreement. Where the parties have informally reached substantial agreement on terms with the intention of embodying such agreement into formal contract, the informal agreement is binding through the formal agreement, though the formal agreement is never drawn up or executed. To this rule, however, there are several exceptions. Where parties do not intend the informal agreement to be binding unless and until the formal agreement is executed. Where the informal agreement is insufficient in law, as in the cases governed by statute of frauds, which statute of frauds needs to be in writing. Like it can't be verbal or through implied. It has to be in writing. An informal writing, if insufficiently definite as to terms, may constitute a binding contract, though it provides for no subsequent formal writing. Example, a document entitled Articles of Agreement, duly executed, states that the parties have agreed to execute a formal lease of specified premises for a specified term at a specified rental. The lease to contain the usual and proper covenants or provisions, right? As to possession, surrender, and delivery, warranty, re-entry, and so on. In brief, all the usual and formal clauses to the mutual satisfaction of the parties. Such writing is binding though it is never followed by a formal lease. It expresses with sufficient definiteness the intention of the parties. Since mutual assent is substantially complete, the expression to the mutual satisfaction of the parties obviously refers to the choice of mutually satisfactory words to express their assent. But like this right here, for like, since they're talking about leases, is what did he say for this example? It had the usual formal clauses, right? The lease to contain the usual proper covenants as to possession, surrender, delivery, warranty, re-entry, and so on. Those things are things that you have to remember that have to be part, that are like statutorily protected or statutorily you wanted to avoid it or something like that, like as the statute won't apply because a default makes it would mean that it would apply if you didn't have it on there or something. Reality of assent. Mutual assent must consist of a real meeting of minds. Factors which may mar or even destroy the reality of mutual assent are fraud, mistake, duress, and undue influence. Fraud defined. Both common law and equity have hesitated to define fraud. For fear, as the court declared in Stonemetz versus Head, that were courts to cramp themselves by defining it with a hard and fast definition, their jurisdiction would be cunningly circumvented at once by new schemes beyond the definition. Nevertheless, the cases teem with definitions of fraud. In the law of contracts, fraud is defined as a reckless or intentional misrepresentation of material fact, in fact inducing one to contract to his injury. Shit, that might be a good court case to read right here, though. Right, Stonemetz. That's this one. It's a Missouri case. Like their whole reasoning, the whole thing is the whole reasoning, right? Aside from what they said here. They said that once we give it a definition, we're always going to be hauled into court to say, no, the definition is this, and we're doing this. That's what he's saying right there. And this right here, number 10, is Corpus Juris Secundum, volume 17. Classifications of fraud. There are numerous classifications of fraud. These are by no means universally accepted as meaning the same thing in different jurisdictions. Among the more common classifications and distinctions are the following. Fraud in the factum, also known as fraud in the procurement, fraud in the execution, and fraud in the inception. This is said to exist when, by trickery, a person is made to sign a different instrument from the one intended, so that there is really no meeting of minds at all. The instrument in this case is a nullity, and the contract is void, not voidable. See section 176. For an example, see section 111, which was above. I'm not going to go back though. B, fraud in the treaty, also known as fraud in the inducement or fraud or antecedent fraud, is fraud occurring during the negotiations which precede the making of the contract. The contract itself is one intended to be made, but the reality of assent is marred by the antecedent fraud, since the contract is valid but voidable at the option of the defrauded party. Actual fraud, as distinguished from constructive fraud, is fraud based on a misrepresentation of fact with intent to deceive. Constructive fraud, also known as legal fraud or fraud in law, is based on a misrepresentation of fact, but on a false violation of duty. It exists regardless of intent to deceive, as a matter of law declared by the court, not as a matter of fact determined by a jury. It frequently results from violation of a fiduciary relationship. Examples. It becomes desirable for XYZ Corporation to buy certain oil wells. The directors form a separate corporation in which they are secretly interested, which buys the oil wells and resells them at a profit to the XYZ Corporation. Such conduct of the directors constitute constructive fraud. They violated their duty. A depositor having a balance of $22,505 with a trust company lost his memory following an illness. An official at the trust company, knowing all the facts but concealing his official position, induced the depositor to contract to pay $10,000 for, revealing the location of the deposit. This said the court was the court was constructive fraud. Actionable fraud. Regardless of the numerous forms of deception may take, the broad term actionable fraud applies to misrepresentation as distinguished from breach of duty. For actionable fraud, certain elements are essential and certain remedies are available. I think I'm going to cut it there for the day. Like I said, there's going to be at least 3 videos. I should just go at least to remedies that'd be 1 more page. Oh, that'd be 2 more pages of all examples. But the next one will be elements of actionable fraud. So when we come back, I'll reread this one, E, right, for one of the examples, and I'll start here. If it was like half a page, I probably would read it right now, but screw that. Yeah, so 126. So hopefully you guys enjoyed, learned something, but for sure pull out a book, especially or read one of these court cases. But always look it up, man. Go on Restatement of Law of Contracts, see what they were saying about that one section. Always reference what you're reading to something else, especially something that you could tie back further in history of time, because that's when people amongst each other were creating principles on how one should behave with transactions with each other. And that's like one of the most important things that, people can do in a society, to communicate with each other. But like and subscribe, guys, for sure. And if you have any questions, you know where to find me on Telegram. If not, send me a message here and I'll answer whatever I can. Good luck and enjoy. Until next time.